Hey, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have an update on the status of Kim Gardner, who is the St. Louis City Circuit prosecuting attorney. The young lady who has been in a great deal of trouble for how her office operates. I'll have more on that in just a second down here at the beach. So one of the things that you don't want to do as a prosecutor is ever have a situation where a case that should be tried gets dismissed. And that's especially true when the subject involves murder. And the other thing that you don't ever really want to do as a prosecuting attorney is have a judge threaten to cite you for contempt. Both of these things have happened with the St. Louis Circuit attorney. She has had numerous staff defections. She currently has 2 prosecutors to handle all the felony cases in her office. 2 prosecutors. So recently, a Missouri Court of Appeals judge, Judge Turbitsky, was appointed to oversee the quo warranto petition that was filed by the Attorney General. And there are a couple of things that really set my teeth on edge with respect to the response that Gardner's attorneys filed. One of them was that the problems in the office are not due to Ms. Gardner. They are due to her staff. So basically, she's throwing her staff under the bus. And when she did that, she lost additional prosecutors. And all of this is making it almost impossible for any of these guys who are defendants in murder cases to get a quick and speedy trial. So, like the predators they are, they're taking advantage of their right to a speedy trial. And if they do not get their trial within the prescribed time by Missouri law, the case has to be dismissed. Now, whether it's dismissed with prejudice, meaning it can never be refiled again, or whether it can later on be refiled again is a matter that I'm not certain of the result. But I can tell you this much, the judges in the St. Louis Circuit do not like what's happening, and they are letting Ms. Gardner know it. In fact, I have some clips to show you from that hearing, and I think you'll find them very, very interesting. So, with that said, let's take a look at the tape and see what's happening.
May it please the court. Again, I'm Jonathan Sternberg, and I represent Circuit Attorney Kim Gardner. Your Honor should dismiss the amended petition in quo warranto that the Attorney General filed in its entirety. It's a poorly considered political move that doesn't remotely state a lawful claim for Ms. Gardner's ouster under the well-established law of Missouri. Under the only authority that the Attorney General has invoked, which is Section 106.220 of the revised statutes, specifically its subsections or subparts allowing for removal of a public officer for, quote, willful or fraudulent violation of a public duty or willful neglect of a public duty, he has to show that Ms. Gardner intentionally failed or refused a duty. He omits that from both his petition and from his response to our motion to dismiss, which was filed yesterday afternoon. And Your Honor, it's the intentional failure to file 95 liquor control cases that they specifically identified. That is not what they allege here.
Here, I mean, if you changed the word willful to intentional in their pleadings, would you then believe that their pleadings were adequate?
No, Your Honor, because the only place the word willful occurs in their pleading repeatedly is in its conclusion, that they conclusively say that Ms. Gardner willfully neglected some duty, all right? But what the well-pleaded facts leading up to that don't allege anything intentional by Ms. Gardner herself at all.
May it please the court.
Counsel.
Mr. Sternberg and Ms. Gardner would like to talk a lot about what the petition doesn't plead, but she doesn't want to talk a lot about what's important under the statute, what duties she has failed or neglected. And there's a replete throughout the amended petition. There are assistant circuit attorneys not showing up in court and having cases dismissed out from under them. There are assistant circuit attorneys unprepared in court and nollying cases on the eve of trial over and over again. When we talk about 19,000 cases, if you add up all the case numbers during Ms. Gardner's term in office, the amended petition pleads that there were 2,700 cases dismissed by the court. A majority of those cases were due to Ms. Gardner's failure to either prosecute those cases, turn over discovery, or comply with speedy trial requirements. There were another.
I think, sorry to cut you off, but I think that let's get down to kind of the big crux of the issue, which was a lot of Mr. Sternberg's argument was, what's in the petition that allows me to make an inference that this conduct was intentional as opposed to just negligent?
Well, the Quo Warranto cases, contrary to Mr. Sternberg's reading, are replete with cases where the neglect of duty, willful neglect, is shown by when a public official knows that they need to do more and fails to do more. So the Olvera case was about a recorder of deeds who swore that certain financial transactions under oath were correct because that's her duty under office. And she argued that many of those entries, she did not know that they were wrong. And she changed one entry believing that she was correcting a mistake, that she was always acting in good faith. And the court granted summary judgment against her, finding that it didn't matter her subjective motive, her excuse for why she failed her duty. What mattered is that she was required to do more to verify that those entries were correct, and she didn't do that. That's what's going on.
So I have one thing that I'm wondering about your petition is that there are 10 different counts. And part of my question is, you're asking for one remedy, removal from office. Are these counts independent of one another? Do they all act together? Is it some of them are like, well, maybe that one's not good, I can knock out a count here and there, or does one depend on the other?
They all could independently require the circuit attorney's removal, but the case law has a lot of discretion in the removal process. We give a lot of trust to our public officials, and a lot of times they get a lot of leeway. And that's why the Attorney General has discretion whether to seek quo warranto, as do local prosecutors. And this court ultimately has discretion to issue the writ if you think it's in the interest of justice or not. I forget the name of a case, but there was a case where an official was, quote, just for sometimes doing work that wasn't of the office while she was on the clock. And the court found that she fulfilled all the rest of her duties. There was no argument that she was doing a good job in office, and the quo wasn't appropriate in that case. But that won't be what the case is at the end of this case. The Attorney General, as pled in the amended petition, will show these repeated failures to do Ms. Gardner's duty require it to be in the interest of justice to remove her from office.
Well, as you can see, this is not a situation that anyone who is a circuit attorney would ever want to be in. However, Ms. Gardner seems to be perfectly okay with it. Instead of sitting in a hearing about how her case is going to progress in quo warranto, she should be hiring additional prosecutors and trying very hard to get these cases moving. But the problem is, you can't just hire a prosecutor off the street. You have to have somebody who's a licensed attorney, and you have to have somebody who understands trial practice, and that's not every attorney. You can't go out and hire somebody who's done probate law all of his life to suddenly become a prosecuting attorney. It just doesn't work that way. You need somebody familiar with trial practice and familiar with the criminal law. Instead of that, what is happening is, in a majority of the criminal cases that are being filed, is it's Monty Hall's let's make a deal. And somebody comes in charged with, aggravated assault. They, get let off for disturbing the peace. It's really a crisis. And the people of St. Louis City are not being protected. So it disturbs me a little bit that the trial in this matter, the matter where the quo warranto petition will be determined, has been put off until September of this year. How that office gets run between now and then is anybody's best guess. But my supposition is that they're going to have a very difficult time prosecuting cases, and defense counsel are going to have a very difficult time trying to get any discovery or anything else out of the circuit attorney's office. So this is one of those situations where hiring, or I should say electing the wrong person, electing a person with a bona fide track record of screwing things up, is not a good idea.
So I had some additional thoughts on this, and starting out, I found it interesting that instead of going and appearing before the circuit court and answering the judge's show cause order, Ms. Gardner somehow found it appropriate to send a prosecutor who was off on leave. Now, that to me doesn't sound like somebody who is taking accountability for her office. She's making somebody give up a day of leave to go in and answer the court's asking questions. So, given the fact that she has thrown her employees under the bus, why would anybody work for her? Why would anybody find that to be fulfilling? You'd know that everything you did would be subject to claiming that if there was an error, it was your fault, even if it wasn't your fault. And the thing that really bothers me the most is that there's a legal rule, a legal ethics rule right on point that says that supervisory attorneys are responsible for their subordinates. That basically if they endorse and approve of their actions, they're responsible. And in this case, I think that's arguable. Now, she can't run a prosecutor's office without attorneys, and no attorney is going to go to work for somebody who is going to throw them under the bus at the end of the day. And that is simply a given. So I believe that the proper course for her here is to simply resign and walk away from this job. I don't believe she's done the citizens of St. Louis any favors. And even though she does seem to have strong support in this community, if they knew what was going on, they would not be so supportive. And I think that's one of the things that one of the main purposes of Bailey's lawsuit here, of his quo warranto lawsuit, is to make sure that the people of St. Louis are familiar with what she's doing and what she has done.
Well, that's what I have for you today. Thank you very much for watching. If you have the opportunity today, go out and do something nice for somebody. It'll make your day. Thank you for watching, and I'll catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.